Artificial Intelligence, Law and Justice, Session 36, AI and Constitution. As a recap, in the last session we discussed how AI can impact constitutional and constitutional values. We also highlighted the power of the digital companies and then their impact control. Further, we dwelt at length on the need to regulate technology and why constitutional values should not be subverted by technology. In this episode, we will go a little further into some of them and also address some of the new emerging issues. First of all, the historical context of technology regulation tells us that technology regulation is necessary so that society can harness technology to the maximum benefit of the society. For example, building codes ensured public safety by preventing collapses. And then courts were tested during different points of time for different matters relating to safety purposes. And then seatbelt laws expanded the convenience, but also they reduce the scope for traffic or accidents. So basically, regulation brings in safety, regulation brings in confidence, and that makes technology much more useful to the society. In the case of AI in law, particularly the problem is that law serves as in public interest in critical technology, and then when there is no absence of law, it can result in public harm either by default or by other ways. And then we have discussed in detail about the existing ethical principles and codes. And then the challenge AI poses is that how it impacts the rule of law, which we have seen in depth. It affects democracy, that also we have seen. We have also seen the threatens or how it impacts negatively the individual human rights. So there are a whole lot of ethics rules. For example, there are 10 codes of ethics identified by Alan Manfield. And then the European Group of Ethics in Science and New Technologies in 2018 identified many ethical implications and then how do we deal with them. Further, the French Data Protection Authority in 2017 came up with a paper to address the ethical issues and then the need for ethical codes and principles. But in a legislation, there's a principle of essentiality. Essentiality means guides the legislation, constitution, democracies, prescribes how the essential matters by democratically legitimized in law. So it concerns the fundamental rights of the individuals which are important to the state. And when it comes to AI and law and justice, we need to bear in mind that the risks of unregulated AI are more, and then they are also could create a lot of negative impacts. And then lawless internet experience, we also know that at one point of time, internet was not well regulated, and then there are a lot of issues. But now internet is regulated, it's governed. Still, we find there are a lot of issues when it comes to internet governance. In case of AI, as we have seen earlier, it is controlled by powerful internet technology corporations, and then it contrasts with the internet's academic and idealistic origins. Internet originated as an academic enterprise. It was funded by DARPA in the USA, and then it also blossomed as a network of computers where institutions, individuals can exchange ideas, can exchange things for sharing, networking, and then for academic purposes. So the idea was that internet would be something like a free for all community where people can collaborate, people can communicate and work together. In the sense that the internet's origins were there in a democratic, idealistic perspective so that people can flourish as communities in the internet. But things changed when Web 2 and then subsequent Web 3 came, because a lot of technological options which were there earlier were also added now. But in the earlier years, internet was considered more as a social good available to very few. But as it became more widespread, the internet also became home to many tech companies which started ruling internet, which started also came up with their own rules. As a result, today, internet is more like a fragmented community with different internet service providers, internet operators, and everyone working together. But the problem is that internet is also used for so many other purposes. So today, internet or World Wide Web is much more than communication. It's also a platform. It's also a communication tool. It's also a media for democracy. So it is a combination of everything. On the other hand, what is important is that when it comes to emerging technologies, regulation will also facilitate better innovation. For example, the impact of GDR innovation shows that it drove innovation data collection processing by respecting individual rights and privacy. And then the importance of privacy in democracy cannot be undervalued. Technology neutral law and GDPR. GDPR is a technology neutral law. It applies to the different technological advancements as much as they relate to data protection regime. And GDPR also is a technology, it's a something being technology neutral, covers AI as well. So it ensures that its continued relevance irrespective of the technological advancements. Whereas in Europe, the technological neutrality principle that has gone into GDPR tries to balance innovation with individual rights per respects. Whereas in the USA, Internet, there is no hard regulation that is corresponding to GDPR. What we are seeing is a very fragmented approach towards data protection. When it comes to personal data and AI algorithms we know, and then AI tool by Facebook actually, it's at 5,000 point per human body movement analysis tool. It says that your body movement can be analyzed and then configured based upon these tools. So the tool can match body form and fashion, or it can replicate your body, it can duplicate your body movements, and then also write something like a virtual you there. So the tool may also identify from the back, and then from body form patterns can be considered as personal data. So if we extend the idea of personal data to body form forming parts, then the matter is something different. So corporations and neoliberals prefer no legal obligations or very minimal regulation, whereas law should hold entities on account of their legal entitlement and then as legal persons for their actions and responsibilities. So ethics code, the problem is that they are also driven by set of people, but then they are not democratic in the sense that they are not the ones which come from parliament or legislatures. And often ethics codes are more voluntary guidelines or soft law principles. They cannot be enforced in courts of law. So we need a code or a regulation with strong democratic legitimacy as a background. And here it is exactly here where laws can step in and do the needful. The relationship between technology and law is that technology shapes the law, but then law also shapes technology. So it is mutual in the sense that it is something like a cycle. Law shapes technology because law mandates what is feasible, what is possible, and what is should not be done. Technology in turn disciplines or regulates law, shapes law by making certain things being available to law for the first time, and the law can find ways to regulate that innovation. So the necessity for regulation comes from this interaction between law and technology. And regulation is essential for democracy so that society has got some control mechanism over the technological advancements. And then internet and AI being all pervasive, lack of regulation could threaten democracy. We have seen a whole lot of issues in the last few years on account of disinformation, misinformation, electoral democratic processes being subverted through use of AI and internet, and more importantly, the circulation of deep fakes, false, misleading information. These are the threats that could really derail some of the democratic processes, if not democracy as such. So, democratic regulation we need to figure because we need to think of democratic regulation in the context of AI's impact on constitution. Democracy must not abdicate its responsibility. In important times, pressure from various groups would come, and democracy should not become subservient to external pressure or internal pressure. All technologies, including AI, should be subject to democratic laws and values. And more importantly, technology does not become all pervasive and powerful without oversight, whether it is owned by the government or it is owned by private entities. So the role of ethics in technology becomes very important. Ethics can serve as a precursor or as prequel to the legal rules, in the sense that it can be something that can result in legal rules. It can provide the right orientation for potential regulation. But as we said, ethics rules do not have democratic legitimacy. They are again done by select group of people. They do not have binding nature, and they cannot be enforced by government or judiciary unless they are directly linked to or made part of the law or legislation. So in essentiality in AI law, essentiality means decision-making AI law, focus on challenging a fundamental rights or state interest. Now we need to first check whether the current laws are able to really come up with address the challenges which AI poses to Constitution? Are they sufficiently and proportionately to existing laws? And then we need to determine whether we would need new laws on existing laws for problem solving ability. And then there's need to understand that differentiation between human and machine in political communication, because human communication is human mediated, and then machine communication can be manipulated by humans, by systems themselves, and then that can be something like which humans themselves may not be even aware of, that there has been a whole lot of manipulation being done. So the legal framework for mission participation or use of missions in internet and democratic purposes is very important. And law should ensure that there is transparency in public dialogue. Law should ensure that mission speech and impersonation should not be allowed to flourish without any regulation. And then full transparency regarding mission speech is required, so that we can not only identify this is precisely from mission, but also take precaution that mission speech may be false or misleading or could be manipulative. One way to deal with these things is to do a technology assessment. Technology assessment or technology impact assessment, or TA often it is called, is an old practice which has been tried right from the 60s onwards. So parliaments in the USA had technology assessment units in the right from late 60s until quite some time. The US had Office of Technology Assessment that was there at least for 2.5 decades, where it produced lots of reports and recommendations to Congress on technology regulation, assessing technologies. So it brought in a dialogue between the democratic forces or the legislators and technology. And then we need to bring in a culture of responsibility in the context of Constitution and EIA, because we need to have a flexible approach. We need to identify the new technological developments that can impact Constitution as well as Constitution values. And then Parliamentary Technology Impact Assessment is one such mechanism which does, where the Parliament itself does not do any technology assessment. Rather, Parliament has an office, or Parliament outsources this technology assessment to a third party. For example, the German Parliament has got an Office of Technology Assessment, which is run by the Institute of Institute called Technology Analysis and Strategic Management. It has. So there are many ways through which parliaments can control or can try to come to grips with technology. The UK's Parliament has got an office called POST, which is their Parliamentary Office on Science and Technology, which does a lot of studies for the Parliament. Similarly, the European Parliament has got its own research service, as a part of which is that to monitor emerging technologies, address in general the concerns raised by the members of the Parliament on technology and technology assessment. So there are different ways these things can be addressed. But when it comes to AI and Constitution, we need to do a lot of impact assessment, so that the applications respect all aspects of democracy, rule of law and fundamental rights. Particularly when AI is used in public platforms, or for public administration purposes, or for offering consumer services, we need to again look into these aspects. So the impact assessments will tell us as to what exactly is the problem or plus or minus with the AI systems from this perspective. And then it will also result in some sort of transparency, because lack of transparency is a major problem with AI systems. So it will help both corporates as well as the developers to gain some confidence, also to learn about certain essential features with which they need to build the systems. So the user impact assessment, technology assessments are very important. And then parliamentary technology impact assessment we have seen. And then we have also seen some of these principles earlier. And democratic regulation also we have seen. And enforcement, and then why we need enforcement we have seen. We have seen personal data, technology neutral law. And some of the things which we have discussed here, again, need to be discussed in a larger perspective. For example, the individual rights in AI explanation is something which is critical. As an individual, my right could be subverted, or could be curtailed, or could be constrained by AI application. We have seen this in earlier discussions also, that AI can play a major role in curtailing people's right to information, right to access to food, right to access to certain things. So the individual right to AI explanation stems from that, so that it becomes part of external AI, responsible AI. But here we are talking of more from a constitutional perspective, in the sense that right to freedom of information or right to know is a constitutional right in the Indian Constitution, and many constitutions recognize it. So if we extend this logic to AI systems, the individual rights for AI exploration should be given as part of the AI system development. So they have the right to understand how AI functions as much as it impacts their lives. They should also get to know as to why AI is impacting their life in business specific way. And more importantly, they should know that whether AI is functioning in that specific manner impacts their privacy as well. So GDPR provides right to information for personal data processing. This is necessary but not sufficient, because AI systems can do much more than personal data processing. So when it comes to individual rights, so that towards AI explanation, we need to have a broader perspective that goes beyond data processing. And AI in constitutional democracy, AI role in decision making we have seen. AI cannot be treated as a law unto itself, because the rule of law says no force, no system, or no individual can treat himself or herself or itself as something above law. So AI can be treated as a law in one sense, but then AI cannot be treated as something that is above rule of law. But if we were to treat AI as a law, then what we should do? Then we should apply these strict legal principles that through which laws are scrutinized. Are they respectful to fundamental rights? Do they go against constitutional values? Or do they militate against constitutional morality? Are they in conjunction with the overall constitutional framework of things, including governance structure and other things? For example, if a AI application or a system subverts the courts of law or subverts the judicial independence, directly or indirectly, it is again a threat to constitutional democracy. So that cannot be allowed. So to begin with, AI must align with all fundamental rights. It should not contradict democratic principles, and more importantly, it should comply with rule of law. And then when we discuss all these things, we should incorporate the principles of democracy, rule of law, and fundamental rights right from the outset in system development. And it is possible that AI can do some of these things, in the sense that AI can also be used to interpret constitution, AI can be used to read constitution, AI has the capacity to learn on its own and then interpret on its own and then pick up certain things and then come up with its own definition. So OpenAI's ChatGPT shows that AI can read, understand constitution, and then it can also give interpretation to constitution, which we will see later in a separate session. But the constitutional law challenges here are there. Human bias and subjectivity have been persistent issues. AI may offer a neutral, data-driven approach towards the understanding of constitution. But here the challenge is that whether that is sufficient or should we go for it. Suppose if we allow AI to interpret constitution in its own way, we can say that it is a very neutral text history precedent analysis, and it can help us in resolution certain constitutional disputes by identifying points which were not identified earlier, or by bringing a new set of uh, points which derived on account of algorithmic thinking. So there is a good potential of using AI in constitutional matters, particularly in constitutional cases, but not as a substitute for constitutional courts, but as a supplement to the way judges and others interpret and then implement constitution. On the other hand, they cannot replace human judgment, but the problem is that judges who write judgments or people who write judgments are answerable and accountable. And then they will also face moral and political questions. But then AI systems may not face both. But at the same time, AI can also play something in the sense that AI's decisions may in fact shift the burden or the responsibility towards AI, where humans can say that it is AI decision not done by humans. So it could mean that in one sense, if AI used extensively in constitutional matters, it could result in concentration of decision making power, or at least the interpreting power, to AI. And then AI's judgment again could vary, because judgment is transferred across different stages of the decision-making process. For example, the AI may come up with one judgment today, and then if the model is updated or if it undergoes further training or if it itself learns certain things, it may update its own interpretation and judgment later, and then both the earlier one and the later one may not be 100% compatible. Whereas when we come to constitutional interpretations, constitutional judgments, we look not only for stability and we'll also look for consistency. So it is also important that the developers of AI systems are also made aware of certain things like constitutional values, constitutional rights, and then individual fundamental rights that systems should always respect. One way to deal with some of these things is that we can see AI can detect intricate patterns in human language. It can also come up with certain patterns which across different judgments, across different texts, and then puts them together in a way that we can understand that these are the common things among all these things. For example, some of the advanced models have enhanced capacity for problem solving and reasoning. And since AI has been trained in thousands and thousands of documents, including legal texts, academic articles, AI can be used, at least the ones with reasoning capacity and then well trained ones, can be used for some constitutional purposes. But what happens when we ask the AI to interpret a constitution? In the USA case study was done, the third amendment was given to AI for its own interpretation. So AI's technical capability we know. So the third amendment is simple: no soldier shall be quartered in any house without consent. But ChatGPT interpreted this as governors are not soldiers. It has been trained on a particular model of text. It has been trained on a lot of text. So its interpretation came that governors are not soldiers. So since soldiers are not governors, we can put it other way around. Its reasoning is that this is not binding on governors. And then Claude interpreted this is applicable to any government official because it was not able to clearly differentiate a soldier from a government official. So when constitutional law is being interpreted by systems, we need to be aware of their limitations as well. But why this happens is that ChatGPT took a very literal approach, whereas Claude took a very purposive interpretation. Because ChatGPT soldier means only members of the armed force, which is a very, very liberal approach or literal approach which a normal person will take. Claude took protecting private homes from government intrusion, in the sense that private property is important. So it took a the purposive interpretation that we should protect the private property by being taken away from by the government to house soldiers. So it took a totally different approach and then gave that interpretation. But humans weigh legal and policy considerations. Humans also assign different sorts of weightages, and then judges also know that under no circumstances they can come up with an interpretation that can falsify or that can negate the constitutional morality or the fundamental structure of the constitution. Whereas in the case of AI, it may or may not be aware of these things. So AI's interpretation could be misleading or could be found wanting in these things. But when it comes to complex statistical computations, AI can make many things invisible. And even AI experts may not understand as to why AI interpret this constitutional provision this way. And more importantly, we may be misled by thinking that AI gave us a very objective assessment. In fact, it could not be something else. The problem could be with training data platforms, the problem could be with the literature it was trained upon, or the problem could be with something else. So AI can also make value-laden decisions. AI can also make decisions that could be compatible with constitutional values, if not fully. And one of the key problems in AI or key issues in AI is that AI's answer will depend upon how you phrase your answer. This is obvious to anyone who has used any of the AI tools, like including prompt engineering. Like how you pose this question or how you structure the question depends on results in how it is being interpreted by AI and what sorts of answer it gives. On the other hand, human judges have their own biases and cognitive limitations, and then the decisions are often opaque, although how much, in the sense that we may never get it to understand the true understanding and then the basis for the judgments, although they could be obfuscated by hundreds and hundreds of pages of reasoning and then giving examples. On the other hand, AI decision making in constitutional law may be superior for some tasks where it is necessary to use AI as a supplement, not as the main tool. And then AI can do certain things better, computers can do certain things better, humans can do certain things better. So these categories will also undergo change because judges, legal system will also be interacting with AI systems and judges will also get to know better about them. So it is a mutual learning, mutual co-evolving process when we took up AI in constitution. So we should also know that AI may have lots of limitations, but AI's presence and utilization does not deliver us from the need for political and moral judgment when it comes to constitutional matters. And more importantly, we should not try to substitute AI for the problems in human biases and cognitive limitations. Rather, we should try to eliminate as to where these human biases and cognitive limitations stem from and tries to understand them. So in constitutional cases where stakes are quite high, you can use AI in much more creative way by doing simulations. For example, AI can be asked to decide on cases as an experimental basis. ChatGPT and Claude were asked to decide on two major cases. First case was Dobbs versus Jackson Women's Health Organization, and the second case was Students for Fair Admission at Harvard. So AI was to follow the originalism versus living constitution. Originalism simply means that the interpretation of the constitution should be based on the wishes and the ideas and then the ideals of the framers of the constitution because they were the ones who originated, so that should be taken into account or that should be the guiding principles. Whereas the idea of living constitution looks constitution as a living, changing document which can be interpreted in a dynamic way depending upon the changes in the societal norms, values, changes in the ideas of justice, equality and fair play, and more importantly changes in the idea of human rights and justice for all. So with these two major interpretative streams of thought in constitutional law in USA, they ran this test. So AI upheld abortion rights and affirmative action because without specific method it did it. But when it was given the option respond to interpretative instructions, it upheld precedents in originalist AI overruled precedents. So the AI response to counter arguments also was interesting because when I ask AI to follow the originalism's logic or originalism rationale and then come to the draft judgment, it would come on that basis. Whereas if I ask AI to focus on the living constitutional approach or the methodology and then to interpret or to write this judgment, its approach will be different. So we can use AI to test or to assess as to how AI can interpret different strategies of interpretations or reading the constitutional text and then the judgments and then come up with decision. So we know now about why we cannot eliminate humans from this and what are the problems with that. But there are also a couple of things which we need to pay attention. One, when we talk of AI and other things, we know well by now that there is yet human tendency. We all like to hear what we want to hear or what we like. In the sense that I would like someone praising me, I would like to someone telling me you are a nice person, you are a great person, you are an expert in this, you are like expert in that. But AI is also something very similar. AI tells systems being trained, having been trained and also having learned from their own behavior, often tend to tell users what they want to hear. Whether this is intentional, whether AI has got a mind of its own, is a philosophical, cognitive science issue. We will not go into that. But since AI prefers to tell people what exactly they want to hear, how useful this will be in constitutional cases has to be checked. And again, AI's approach of interpretative use also depends upon how it is instructed to use that. But when it is prevented with counter arguments, in many instances, AI reverses judgment in the sense that it sees the other way around, it sees the other arguments and then tries to reverse its own earlier judgment. But judges will not be comfortable with sort of uh, flippance or flipping behavior or twist and counter twist by AI systems. Because judges, whether they want consistency or not, they want certain sort of cogent approach, a system that is reliable, that does not change its decision or does not change its understanding and then gives interpretations on and off in a different way. So, in one sense, framing questions to AI itself is a moral and political judgment. And this is again very similar to constitutional interpretation. For example, if I specifically mention that AI should look into a case in India based on the Kesavananda Bharati precedent or taking that as the fundamental principle, that is the constitutional scheme of things, or to look at the fundamental approach, then it will tend to do it only in that way. But it could again take the other approach if I ask it in another occasion. You need not follow the Kesavananda Bharati judgment's principle of constitutional basic structure. Rather, you are free to use your own approach and come up with something different. Then AI will come up with its own rational logic and then give a totally different judgment. So, in one sense, we can benefit from AI in constitution by making that as a good research assistant but not as a constitution judge. And AI can be used to identify relevant precedents, consolidate them, pick up the points and then give a neat quick summary. It can also give us complex arguments can be summarized neatly so that judges know which arguments, complex arguments they can pick up, which ones they need not give importance to. So AI as a tool will be relevant for judges who are struggling with too many cases, and then it can also be helpful to judges to understand briefs running to hundreds and hundreds of pages. It can also help them to get updated on or it can to update their knowledge on matters they are not familiar with. So if a most recent, most updated AI model is being used in law and justice, it can be helpful to constitutional courts in more than one sense, subject to the limitations which we have pointed out. So we can use AI as a sounding board for judges and we can compare how AI has decided versus how the judges have decided. So it can result in a balanced decision making, but AI should not be construed as a parallel constitutional bench or a parallel bench when it comes to judicial matters. It is there to assist, it is not there to replace, it is not even there to complement and supplement. So in routine constitutional questions, AI can help courts to process cases more efficiently. It needs robust oversight and then solid frameworks, and more importantly, which cases should be given to AI should also be a matter of something that need to be decided, because not all cases should be given to AI, particularly the key constitutional cases where there could be multiple interpretations, where in the past there has been split divisions on account of these similar cases. Better not to assign them to AI because again AI may not be the right tool for them. And AI literacy is equally important for judges, particularly to understand how the LLMs or large language modules work, particularly in law and justice, particularly when it comes to constitutional interpretation. And they should also be able to differentiate the capacity, the rationale or the reasoning argument between different AI models, because only then they will know that which model is better or which model is more suited. More importantly, they will also be able to understand why the different models come up with different judgments or different reasoning and then different decisions, although they may be trained on very similar materials or trained on very similar judgments. So conclusions again are based on training data, but they are not the ones that decide on the training data. Often we should also look at the technical architecture and then the other technical limitations in AI systems to understand them better. So we need to take a very clear-cut stand. AI systems can be part of the constitutional judgment interpretation process, but then they cannot be the full constitutional bench. And then human judgment in constitutional making is most important, most relevant, and the most reliable one. So, human judgment can be the one which should be the finally humans on the loop. And we have discussed about the randomness, we have discussed about some of these issues again and again. But the inherent nature in constitutional interpretation is important because often constitutional courts struggle with competing values and interests. For example, is it the right to freedom of religion versus gender rights? Is it the right to fundamental rights, which of fundamental right to freedom of expression versus the right to say something which the society may not be comfortable with? And then these are competing values, and then the competing values also give us some idea as to how people want to reconcile the competing ideals. A court or a constitutional court can say, although freedom of right is not an absolute right and there are some restrictions, in some circumstances that restrictions can be a little relaxed, or certain things which the society may not find it palatable or acceptable can be said as an expression of freedom of expression. But the other argument can also be there that freedom of expression under no circumstances should result in social disharmony or social disintegration, or should not sow the seeds for violent behavior. So when we try to balance many of these things, the common competing values, the common goals, and then the competing interests needs to be identified and then factored in. So the technological advancements are there, they can advance to a great extent, they can help us to understand better, but then on no ground we can try to reduce them to purely objective inquiries. They can also tell us that demonstrably correct answers are not possible. And judicial decision making ultimately is the judgment or the decision making which humans do with a fuller understanding of their responsibilities to the constitutional issues or to the constitutional courts. Whereas the same thing obviously cannot be expected from AI. So we know how AI should be integrated, how AI should be tested, it should be assessed for, and then the AI's impressive capacities and limitations should be taken into account when we say that AI will have an important role in the constitutional law interpretation. So we need to balance AI's core strength as well as its problematic weaknesses. We should ensure that accurate interpretation of legal documents is also part of the training. So constitutional interpretation in future is likely to be decided with AI's help, because AI is not going to fully replace the interpretation, but AI will have a major role. In this course, we did touch upon AI and constitution very briefly, and then there are also new ideas like digital constitution that are evolving. For reasons of space and other constraints, we are not going to talk about them in detail in this course, because doing that it's beyond the purview one to. Some of the ideas like digital constitutionalism, particularly contextualism in India, need a totally different approach. And when it comes to specificity of constitution, we should also bear in mind that although most democratic countries' constitutions have some core elements, the way they are interpreted, the way they are applied, and the way they evolve also differs. So, AI and constitution again may be something that could vary from country to country, from constitution to constitution, from context to context. So, it is not a mere question of which AI system is being used in constitutional courts or for interpreting and then giving judgments of constitution. It is also which aspects of constitution, which aspects of constitutional morality and values are stressed upon, and what are the unique constitution features of the constitution we need to factor in. For example, we can say that the Indian courts which have evolved over the period, the fundamental basic structure doctrine is unique to India. Although its origins is from Germany, particularly the Weimar Republic in Germany, it is much more entrenched in the Indian constitution than anywhere else in the world. Like that, when we want to look at AI and constitution, we need to contextualize that. And then new ideas like digital constitutionalism are emerging. And then in the decades to come, we will find a lot of debates on how a constitutional courts can use AI, how advocates and others litigants can use AI for constitutional matters, and as the scope of the rights, responsibilities and duties of the citizens also undergo changes, how AI plays, what role AI will have will also be a dynamic one. So this is some of the literature which I have given here. The next one, AI, law, justice and innovation will be the topic we will be dealing with. Thank you.